Richard Lyman Bushman is the Gouverneur Morris Professor of History Emeritus at Columbia University in New York City. From fall of 2008 to 2011, he was the visiting Howard W. Hunter Chair of Mormon Studies at Claremont Graduate University in California. He was educated at Harvard College. He earned his Master's of Arts in History and a PhD in History of American Civilization from Harvard University. His first book, From Puritan to Yankee, Character and the Social Order in Connecticut, 1690 to 1765, was awarded the Bancroft Prize. He also published Joseph Smith and the Beginnings of Mormonism, King and People in Provincial Massachusetts, The Refinement of America, Persons, Houses, Cities, and also, most recently, Joseph Smith, Rough Stone Rolling. We are thrilled to have him speak to us tonight on the topic is When Law Fails, Joseph Smith and the Persecution of the Mormons. And I will turn the time over to Richard Bushman.
It's a great pleasure to be here tonight, and thanks to Carter Nelson for organizing this event, bringing us together and inviting me to speak. It's always good for those of us who live uptown to come to the village once in a while. When I get here, I always feel like this is the place where it's happening. When you walk by the Blue Note on your way to the event, you know you're in the middle of things. So thanks for doing that alone. Carter wanted me to talk a little bit about Mormons and the law, which is increasingly a very significant topic. You all are aware that there's an active effort to collect all the papers of Joseph Smith and publish them, and they're been coming out pretty regularly for the last 6 or 8 years. And people always ask, what has been discovered? What is new in all this efforts to collect everything connected with Joseph Smith? And the big new is the law cases. We're finding more and more suits that he was involved in. Of course, in his life, there were something like 200 individual cases where he was involved. So we have to think of Joseph Smith as, from a very early age, being a party to a suit somewhere, wherever he happened to live. And I think when the next biography of Joseph Smith is written, that will be one of the new changes that will have to be introduced. The fact that this person was always being harassed by the law and using the law to defend himself for good and ill. Of course, the theme of Mormons and the law always brings to the minds of law students the famous Reynolds case in 1879, where a practicing and admitted polygamist was put on trial and convicted. Polygamy was against the law and was also morally repugnant to most of the nation. And Reynolds presented the case that he practiced this form of marriage as a tenet of his religion. And so it established that issue very clearly in the history of law and is referred to down to this day when similar cases are forever being brought before the courts. Law schools may pay less attention to the tangle of events in the 1830s and 40s, where Mormons were being driven from their homes, deprived of property, and physically abused, and so were involved in legal-type situations, but no landmark cases ever emerged from this set of conflicts because they never got into court, and that is the point. Events that should have led to a suit or a charge of some kind never came to fruition. The Mormons were failed by the law and by all legal and governmental institutions. They're not alone in this, of course. There are many significant portions of the American population that have been deprived of property or life without recourse to law. We think immediately of the Native American Indians who were driven by farmers moving west, driven out of their lands. The Japanese were interned during World War II, and of course the closest parallel are all the black lynchings in the South in the 19th and early 20th century. In 1835 alone, in the South, there were 79 riots in which 63 people died. And only in 4 of those 79 cases was there any form of official intervention, investigation, or arrest, or anything of that kind. So this persecution of peoples who are felt to be alien in the community is a fairly common event in American history. I think the Mormons are an interesting case because their issues are so lucid, they're so starkly drawn, and so protracted. They go on and on for a number of years. These cases, to my way of thinking, raise 2 questions. The first is, why is it that law-abiding citizens will at certain points in their lives turn on other members of the society, step outside the law, and damage the persecuted parties quite illegally? The people who went after the Mormons were not thugs. They were upstanding citizens, future mayors, justices of the peace. How could they justify their outrageous action? The second question is, how should a persecuted group react to such treatment? What is a weak minority to do in the face of the tyranny of the majority, which American society is very difficult to resist? What avenues are left open to them to achieve peace? I will say, to tell the story immediately, that the Mormons seem to indicate that after trying a variety of responses, racking the brains to know what to do next, they found that there was no satisfactory answer other than to flee. So how does it all begin? The Mormons began filtering into Jackson County, Missouri in the summer and spring of 1831, right out at the edge of white settlement in the middle of North America. By 1833, there were 1,300 Mormons in the county. In July of that year, the various citizens in Jackson County delivered an ultimatum to the Mormons that they must leave. When there was a hesitation on the part of their leadership, the bishop, the ecclesiastical leader of the group, was tarred and feathered. The press of W.W. Phelps, a leading writer and intellectual, was destroyed. And various other kinds of depredations occurred almost immediately. Under this kind of pressure, the Mormons agreed to leave. The group who did this was quite explicit about why they were acting so. They actually published a manifesto, and in it they spoke of the Mormons as undesirable citizens. They were poor to begin with. They were suspected of encouraging the migration of free blacks into Jackson County, which in a slave society, of course, is anathema. And above all, they were thought to be religious fanatics, all of which disqualified them to remain in the county. If the Mormons had been a tiny minority, they probably would have been tolerated. But they were arriving at such a rate that they threatened to soon be a majority in Jackson County, which meant that they would control elections. And that would mean jurors and justices of the peace and sheriffs would be Mormons, and for the non-Mormons to have their lives and their property in the hands of religious fanatics was absolutely unbearable. So, under duress, the Mormons agreed to go, and the violence halted, but it did not end. There followed 3 months of negotiations, more violence, and the Mormons attempted to find redress at every level, county, state, and national governments. They sent an appeal to the governor asking for protection, send in a militia to stop those who are damaging our property. The governor advised the Mormons to bring a suit into a circuit court and appeal to the Justice of the Peace. Following his advice, the Mormons hired a lawyer. This act of hiring a lawyer enraged the citizens of Jackson County. They had warned the Mormons explicitly against seeking legal redress. They didn't want any kind of resistance to the demands, either legal or physical. So the citizens seemed to feel that they knew they were acting outside the law, and they wanted to keep the case in that realm. All local officials refused to charge anyone who was brought before a court with a story of assailing a Mormon. Someone was caught throwing brickbats at the Mormon store, and when brought before the judge accused the Mormon of attempting false imprisonment. So there was no help in the local courts. The colonel of the county militia demanded the Mormons give up their arms for the sake of peace, saying that the citizens on the other side would also be similarly disarmed. They were not. And as soon as the Mormons were disarmed, then the citizens descended on them, drove out their cattle, ripped the roofs off their houses, their log cabins, exposed them to the weather, and forced the entire body of Mormons to cross the Missouri into Clay County. One of the peculiarities of this event was that the citizens in the rest of the state, even nearby counties, were sympathetic to the Mormons and aghast at the actions of the Jackson County citizens. The editor of the Missouri Republican wrote, "It is possible to foresee what is to be the result of this singular and outrageous violation of the laws. We fear that the party opposed to the Mormons will think themselves placed so far beyond the pale of law as to continue utterly regardless of law." The state in general seemed to feel that way. The Attorney General promised that he would send in a military force to help them regain their property, and suggested they form a militia of their own, which was possible to do. Any group could form a militia that wanted to, and he would issue them state arms. A circuit court judge agreed to come to Jackson County to conduct a court of inquiry, saying it is a disgrace to the state for such actions to happen within its limits. The governor himself ordered a court of inquiry. But all this came to naught. When the court attempted to gather, it was called off. The once sympathetic Attorney General concluded that criminal prosecutions were impossible given the state of public opinion in Jackson County. Their guards had been sent in to protect the Mormon witnesses who feared for their lives when they crossed back over the Missouri from Clay County to testify in court, and seeing that this would lead to tragedy, this guard was dismissed, which indeed meant no Mormon could appear in court. The Mormons then went on to appeal to President Jackson in April 1834, asking him to call out the militia, and the president said, "I have no right to call out the militia to aid the enforcement of state laws." They went to the governor and asked him to join in the petition to Jackson, and he said, "The laws, both civil and military, seem deficient in affording your society proper protection. He admitted a more clear and indisputable right does not exist than that of the Mormon people, and yet under our present law, conviction for any violence committed upon a Mormon cannot be had in Jackson County. The government and all the institutions of justice were in their feeble, unable to work. So the result was the Mormons found no redress at any level. So to the question, why was this? Why did upstanding citizens take such drastic action when people outside of their own group, in their own state, not Mormons but everyone else, thought their actions were outrageous? Those who signed this manifesto did it openly with pride. They did it on the steps of the courthouse. It was not a plot that hatched in some back room somewhere. They signed their names and their offices to this manifesto. So how could this be? Well, looking back, we can see that the Jackson County citizenry acted in an honored tradition. They drove the Mormons out under a code that goes back many centuries in Anglo-American culture and played a large role in the build-up to the American Revolution. The justifications finds its origin in the notion of the posse comitatus, a posse composed of the whole people, the community. It harks back to a time when law enforcement was weak. There used to be no police forces, not really until the 1840s do you have police forces. And the whole people had to step in to act in the case of a crime. The traditional cry, "Stop thief," in effect deputized everyone in the sound of that voice to stop the specified person as he or she led the scene of a crime. Under these rules of the community as law enforcement, it could decide that a person or group was a danger to society and had to be halted in the course of action. So that was ruinous to the community. In the colonial period, in times of war, sometimes merchants taking advantage of stopping sea traffic would raise the prices of wheat. And there are stories told of the wives of the community gathering around and forming what we would think was a mob to attack these merchants' warehouses and extract flour and wheat from them. During the Revolution, of course, the stamp men who were selling stamp paper were attacked and tarred and feathered, hung in effigy and so on. Custom officers received the same treatment. And of course, there's a famous dumping of tea in Boston Harbor. In all of these instances, the citizenry took the law into their own hands and used coercive and violent action against government officials, against hated members of the city, and all in the name of the good of the community. Now, to pull this off, they had to follow a certain code. They had to prove they were acting on behalf of the people, that is, the whole community, not in self-interest. And that demanded that they observe certain rules. For example, they had to represent the whole community. They could not be one partisan group. And particularly, they could not be just the poor. The poor could not be trusted because they had no stake in the community, they had no property. And so they would, of course, be willing to use any violent action to improve their lot. They were referred to as the mobility, those who have no roots in society, have no property. And that word mobility is shortened to the word mob. So when you say a mob is attacking, that is a political statement, is ideologically condemning a group as not representing the whole community, but only this portion, this property portion was not to be trusted. So sympathetic newspaper accounts of mob actions
through the revolution, made a point of saying that people of property and standing were seen in the crowd that took the action, in order to demonstrate it's the whole community, it's the people who are acting, not just one faction. The second rule was that the crowd had to have a pointed purpose. It could not just go on a rampage, destroying everything in its path or looting promiscuously. It had to have a targeted end in keeping with the public good. So there's the story of the Boston Tea Party where a mob or a crowd went aboard the ship in Boston Harbor, dumped 9 million pounds worth of tea into the harbor, and then afterwards returned to repair a doorknob that they had damaged on the ship. In order to, it was a symbolic action to say, we're not going to hurt anything. We have this narrow, sharply defined purpose in the tea. Well, it's because the people of Jackson County felt that they were acting in this tradition, that they could meet on the courthouse steps and announce their intentions to the world, just as the American revolutionaries had done. After signing the manifesto, they gave their civil positions: county clerk, deputy county clerk, Indian agent, postmaster, colonel, judge of the court. And at the end they said, we each pledge to each other our bodily powers, our lives, our fortunes, and sacred honor, echoing the words of the Declaration of Independence. They're acting under the mandate of the American Revolutionary tradition to drive out the Mormons. Of course, all of that justification didn't help the Mormons at all. They were still faced with the problem of how to react to these people. Joseph Smith himself was personally responsible. After all, it was the religion that he was teaching that brought these people into this difficult situation. And he saw, after Jackson County, that this could happen anywhere the Mormons went, as indeed it did. And the question was, what was he to do? They moved to cross the river and eventually into 2 counties, Caldwell and Davis counties, in northern Missouri, where they made their home. They had not been there very long, really less than a year before these pressures began to mount again. And what were they to do? Well, inevitably, the alternative of self-defense would come to mind. This was an age of fighting, honor, and self-defense was the natural way to respond. When the pressures began to build up in Missouri, and the little Mormon community, DeWitt, was attacked by anti-Mormon forces, and houses were burned, the usual suffering began to occur. The Mormon leadership gathered together, and of course what they said did not go on record and was not publicly known, but a man named W.W. Phelps, who was a confidant of Joseph Smith's, overheard a conversation between Joseph Smith and Lyman White. Lyman White was a faithful convert from the Kirtland days, but also on the bellicose side. And according to Phelps, White asked J. Smith twice if he had come to the point now to resist the law, that he wanted this matter now distinctly understood. We've got to decide. We're going to go by law, which is fairless, or we're going to take matters into our own hands. Smith replied, according to Phelps, the time had come when he should resist all law. In the forepart of the night after my arrival, I heard a good deal of conversation about drawing out the mob from Davis. I heard J. Smith remark there was a store at Gallatin and a grocery at Millport. And in the morning after the conversation between Smith and White about resisting the law, a plan of operation was agreed on, which was the captain, Fear Not, nicknamed a man named David Patton, who was present, should take a company of 100 men or more and go to Gallatin and take it that day. To take the goods out of the store to Gallatin, bring them to Adirondack and burn the store. According to Phelps, Joseph Smith agreed. And apparently the tactic was to drive the non-Mormons out of Davis County where they would not be around to threaten the Saints and to take their property as reparations. They're now thinking it's like war, not thinking civil justice, they're thinking war justice. Everybody is an enemy. You can take the reparations from Davis County people, even though it's the people in Jackson County who caused you the trouble. So on October 18th, the Mormons attacked. Joseph was probably with them, though not in command. What happened is unclear, but the Mormons certainly confiscated property. They were later accused of burning houses, which would be logical, probably did happen along the way. So self-defense was attempted. But the outcome, as we know, was a disaster for Mormons. By taking the law into their own hands, they brought down the wrath of the government. The governor ordered the Mormons driven from the state or exterminated. Through the winter and spring of 1839, the Mormons moved once again, this time eastward to Illinois and a new settlement site. Joseph Smith himself left Missouri with a keen sense of the helplessness of the situation. He learned a lesson. He could not stand up to the united forces of the state in the form of militias. He did not want to sacrifice his people in a Pyrrhic victory by acting again militarily to satisfy the desire to act. Yet, he could find no one at any level of government who would come to his aid. He was desperate and hopelessly frustrated. Driven from Missouri, the Mormons found refuge in Hancock County, Illinois, on the Mississippi River. In their settlement, which they named Nauvoo, Joseph Smith adopted two tactics in hopes of stemming the opposition, which he was certain would rise again. The first was to form a court system under Mormon control, that is, within a Mormon area where they controlled the justice who sat on the bench and where justice could be administered, as they would say, fairly. By fairly, they meant on their behalf. This key feature is a municipal court where the cases of any offending saint and any Mormon who was charged could be tried before a sympathetic judge. If Mormons were to be tried, he wanted a court where he could achieve justice. We now think that he stretched the presumed powers of the court to the breaking point. He claimed that this municipal court could hear the case of anyone charged on any crime to obtain a writ of habeas corpus, that is to be determined whether they could be held in prison. And when he was told, well, the city court can only hear cases under city law, he promptly passed a law forbidding the arrest of Joseph Smith. If anyone tried to come in and arrest him, he could go to municipal court and obtain a writ of habeas corpus. It seemed a little far-fetched at the time and the day too, but there were plenty of advisors who, many of the politicians who wanted the Mormon vote, who sustained this interpretation. And the court worked to a certain extent. When Missouri attempted to extradite Joseph Smith, bringing back the trial for events that had taken place there, and he knew his life was gone if he once crossed the Mississippi River, he was brought into the municipal court and released. So it was effective, at least to that extent. That's his first expedient. Establish a court where he could obtain the justice that he wanted. The second expedient was to form a militia with himself in command. This was perfectly legal in the state of Illinois. Any group could begin a militia. Cities and towns were urged to form militias in order to defend themselves in case of Indian attack or anything else. He went to with a right goodwill, enlisted 5,000 men, a huge militia by the standards of that day. But it's not clear that he ever planned to deploy this militia in defense of the saints. The aim seemed to be more to intimidate his enemies. He specialized in martial drills on civic occasions, inspecting the troops, wearing an elegant uniform and a sword. The martial ardor and display seemed to be the highest function of the militia. As an actual instrument of war, the militia did nothing. When they were in actual danger of attack, the leadership ordered the militia to stand down. After Joseph Smith was killed, the orders went out immediately. Do nothing. The people of the state, as soon as Joseph was killed, fled Carthage, fearing that that Nauvoo militia would come out and burn down the countryside. But they did nothing. They just sat there. So the point of the militia seemed to be to scare their enemies, or rather than to defeat them. Neither of these measures, the court or the militia, seemed to work very well. Pressure against the Mormons seemed to grow, with harassments of various sorts erupting as ever. The story is very complicated over the next few years, but eventually Joseph Smith was arrested and tried in Carthage, the county seat near to Nauvoo, where he was living. And while he was in prison, the mob assailed the jail, and he was shot. As I say, the citizens fled in terror, thinking the Mormons would come after them, but there was only quiet mourning in Nauvoo. Events after Joseph Smith's death confirmed the failure of Joseph Smith's strategy. The municipal court had not worked very well. The huge Nauvoo militia had not frightened anyone. The Carthage mob had struck down Joseph Smith. And over the next year and a half after his death, the opposition grew stronger and stronger. Mobs began to burn Mormon haystacks and ride out their cattle. The only answer was departure. Democratic society simply could not tolerate the presence of Mormons. The governor at the time, Thomas Ford, was furious with the citizens who gathered to destroy Joseph Smith. He saw their strategy as a provocative action that would elicit a defensive reaction, which would then justify slaughter. The state forces, the militia, the mobs could move in and eradicate the saints. But even though he was sympathetic to the Mormons and furious with the rest of the citizens, he could see no solution to the growing animosity in Hancock County. Eventually, he persuaded Brigham Young that the saints must go. So in midwinter 1846, long before they were ready, and months before the trails were open, the Mormons left Nauvoo. They fled, their ultimate solution to their dilemma. That, unfortunately, was not the end of the story. The Mormons left with heady, but also with bitter hearts. Their history in Missouri and Illinois had poisoned them. Many of the saints who left the United States were outraged. Quite a number had vengeance on their minds. After the Missouri Wars, Allison Ripley, just an ordinary letter to say, had told Joseph Smith, "When I reflect upon the cause of your affliction, it is like fire in my bones, and burns against your enemies to the bare hilt. Those who were butchered at Pond's Mill cry for vengeance. I, from this day, declare myself the avenger of the blood of these innocent men and the innocent cause of Zion." That fire in the bones is perhaps the primary cause of the unending war and strife that has blighted the world and continues to this day. It bore its evil fruit in Mormon history at Mountain Meadows, Utah, in 1856, when Mormons lashed out against a band of migrants on their way to California, whom they viewed as part of the army that was at that time approaching Utah to conquer and take over the government. They saw these migrants as the enemy, who would in one way or another do the Mormons harm. Speaking now as a Mormon, I've wondered why that terrible event occurred. Why did honorable Mormon men slaughter over 100 innocent non-Mormon migrants? Why did it happen? Not just on the ground, but why in the great scheme of things? Why is Mormon collective memory burdened with this shame, which is thrown in the face of Mormons as much today as ever? I have no more insight into why this tragedy occurred than the next person. Perhaps one explanation is that Mormons needed a great crime against innocent people, committed by themselves, to purge and calm the terrible anger which accompanied the Mormon people when they left the United States in 1846. That chain of anger and hatred began in Jackson County when Mormons were treated as enemies and grew stronger and more virulent until the assassination of their prophet and eviction from Nauvoo. How could that anger and hatred be purged from Mormon culture? Certainly not by punishment or by pleading. I think it was in effect cleansed in Mountain Meadows. Mormons performed an act of vengeance so gruesome, so horrible, that it purged their memory. We can no longer bear a grudge against violence because we performed an act of senseless violence ourselves. Though Mormons must suffer for Mountain Meadows, with little hope of our plight being understood, we learned once and for all that when law fails, violence is not the answer. Thank you.
Thank you very much, Richard. We would just like to take maybe 10, 15 minutes and answer questions, if anyone has any questions.
Yeah, as far as the state laws and so forth, like sort of Illinois versus Western Mississippi versus New York, Boston, etc. I mean, my guesstimation is that the laws are vastly different. I mean, did you find that in history, like people in New York, Boston, Virginia, thought of this place, Illinois, and this area as like, you know, way far out there with different rules, and so they killed a bunch of Mormons. So what? I mean, is that how they? I mean, how did they grasp that? I mean, and did they have vastly different laws than they had in Illinois and Western Mississippi? I keep wondering if Western Mississippi had different laws versus the East.
I don't think it was actually the legislation or the statutes. There may have been a different attitude toward law. Certainly there are sectional differences. The mob actions that occur, of which there are many, I just referred to one said in 1835 through this period, are focused in the South and the West. There are some in Boston, however. And of course, we know that during the Civil War you have the draft riots, where the Irish rise up against the society. So I'm not sure that just the legal structure, but maybe attitudes towards the law were sort of more tolerant of extreme actions in some places than another. But no place in the United States is totally exempt from that kind of crowd action in those days.
Yeah, back at that time that Joseph Smith was murdered, the U.S. had the Bill of Rights in place and certain human rights in place. There was the Fifth Amendment guaranteeing persons of life, liberty, and property against action by the federal government. And it wasn't until after the Civil War that the 14th Amendment was passed, where those same rights were guaranteed against state action. Did Missouri have any Bill of Rights or any civil rights at that time in their constitution that you're aware of? You know.
Well, the question is, did Missouri have civil rights in its constitution? I can't take them all off for you, but there was no question that the law had been broken. It isn't a matter, this was within the law. This is outside the law. It's extra legal. It has this other form of justification in the form of public action to achieve a public good, even though the law cannot be respected. The fact that the governor acknowledged that an error had been made in Jackson County, I think is an indication that this is not a disputable point, really. It's a question of what legal system you're in. What is your frame of mind? It's just like I suggested, in a state of war, we don't prosecute individual soldiers for shooting soldiers at the enemy. Everybody is the enemy. It's not a civil situation, it's a war situation. Well, this mob scene is kind of a liminal state, somewhere between war and civil action. The people act on their own behalf. That's the point I'm trying to make.
I'm wondering if you can talk a little bit about where the animosity came from around the Mormons. I mean, you know, if you say that this one county really didn't like Mormons, but the other surrounding areas felt favorable or felt embarrassed by the treatment that their fellow citizens were giving the Mormons.
Yeah.
I'm wondering if you can talk more about, like, you know, where that came from.
Where does the animosity against the Mormons come from? It's a very good question, because the true thing is when the Mormons leave Jackson County, cross the river into Clay County welcomes them generously. Of course, we will give you refuge. You've been abused. Within 2 years, the Mormons had to leave Clay County because anger had been built up to such a great extent that they were no longer safe there. And the same thing happened in Hancock County and Quincy, Illinois. They too said, oh, we welcome you, you've been abused. But once the Mormons are there, this animosity goes up. So it's, and that's true all through the time when Joseph Smith is killed. There's sort of sympathy for the way he's been treated in the United States at large. So there's a little mystery in there. It's a little hard to understand. Are Mormons really so repugnant that the more you know them, the more you hate them? I personally think it's this matter of political domination. See, in Hancock County, again, the Mormons were on the verge of controlling elections. It's one thing to have a Mormon as your neighbor, maybe even as your lawyer, but as President of the United States, it raises another set of issues. At this point, it's not President of the United States, it's are you willing to have them as the justice that sits on in the court? And I really can't do anything out of that. All sorts of things were said about them. They're thieves, they're counterfeiters, but those are very hard to pin down as real charges. They seem to be sort of a bias that these are despicable people and they're doing sorts of despicable things. You can't really trust those, all of that specifically.
Is that doorknob story true?
Well, I like to tell it, yeah.
All right.
It's told, even if it's told after the fact, it's a representation of what these people thought they were doing. They wanted to prove themselves.
The other thing that I was thinking about, and I'm not sure how to pose a question about it, but in contrast to a completely different government, I've been interested in Helmut Hübner, who was a Mormon during the Second World War, and he formed a resistance himself, and then was discovered and arrested, and he was excommunicated and then executed. And I really don't know how to. I'm curious about how the people that were around him that were also Mormons thought about what was going on, and how law failed to kind of.
What I hear in your question is Mormons object to others when they're mistreated contrary to law, but are Mormons themselves ever willing to stand against the government? Schumer stood against the Nazi government. Is that sort of what you're getting at? So, actually, there's quite an interesting history of that, because in Missouri, in the 1838, there's a group that's formed called the Danites, whose job is to drive out of the county people who are causing trouble. And the justification given was not that it was legal, but it was the will of the community. This is voiced by the counselor, Joseph Smith, Sidney Rigdon, who adopts the very same language and line of reasoning that their enemies had in Jackson County. So I think it's an example of that there is not just one Mormon stance, we always obey the law and we're always hurt by the law, but Mormons will turn that around as the situation requires. I think it's inevitable that would happen.
Would you say that Mormons were uniquely under-supported by the government, or by the state and federal government, or would you say that in this period, the mid-1800s, that the state and federal governments were not effective in supporting religious minorities?
Well, I'm not saying that they failed to support all religious minorities, but there are other cases, like a Catholic convent in Bern in Boston, which is often cited as an example. So I don't think they're unique. They're unique in the size of the group that's involved and the repeated depredations. But as I say, there are all sorts of others. Blacks, lynchings in the South, abolitionists are subject of now. 1637, Elijah Lovejoy was killed in Illinois by a mob. So no, I don't think they're unique. They're just unique in the size and the number of people that are involved. Yes, in the back.
Perhaps it's easy for me to say from this removed, but I have never been able to see justification for the destruction of the Nauvoo expositor. And I wonder if there's any context you would supply that would make me more sympathetic.
Yeah, this is a case, as many of you know, where a paper had been started in the spring of 1844 by a group of dissident Mormons to sort of rally other Mormons to the cause to sort of oust Joseph Smith. The aim was to displace him and reform Mormonism. And the city council met, debated, and finally voted to suppress the press. And as it's been looked at by legal historians, and it was viewed at the time by the governor, they had a right to suppress a public nuisance. Joseph Smith and the city council thought of the Nauvoo expositor as a match in a tinderbox. They knew they were surrounded by enemies, and they were giving the enemies a cause to attack them. Where the governor departed from what they had done and brought a charge against Joseph Smith was they destroyed the press. They could have stopped the newspaper from publishing, but they should not have destroyed his property. So in political terms, it was a disaster. Freedom of the press in the United States, an honored value, you're suppressing free speech, that's not going to win you any friends or enemies. But legally speaking, they debated this at great length, and law books out on the table, they were hunting all over, trying to figure out, do we have a justification? Legally speaking, you could make a case they were suppressing a dangerous public nuisance. But they did not have any rights to destroy the property. Okay, one more question, and I think.
Sorry, but until what year in the United States could you legally kill someone if you had a mutual disagreement? Because, I mean, you know, Aaron Burr, of course, in our own East Coast world was, I guess he was the one who got shot. Or, like, so do you recall until what year people could actually kill each other because they had
Yeah.
disagreement?
There's a very strong anti-dueling movement that's going through the 19th century. I don't think it's ever legal. I think it was overlooked as a matter of general honor. It's like a husband has the right to shoot a man he finds in bed with his wife. You can't really do that legally, but no jury would convict you from.
So when did that, like, start disappearing?
Then it begins to die out. It's not really as big in the United States as it was in other parts of the world, but Andrew Jackson is involved in a duel. It's this famous case where he wasn't the best shot, but when he lined up with his antagonist, he put himself to the side this way and wore a heavy, heavy overcoat. And so the guy did shoot him, but Andrew Jackson, steely Andrew Jackson, shot the other guy and killed him before he fell to the ground, wounded himself. So that's in, 1820s sometime. So it's still the practice of men of honor. I couldn't tell you when the last duel was fought in the United States, but it's in that 30 to 50 period that it's, that practice is going to stop. Thank you all very much.